I want to say first and foremost that this decision has weighted heavily on myself. I think the past couple of hours have shown this courtroom and whoever is watching that what occurred here was a tragedy. It should not have happened. And no matter what this court does, it's not going to restore the loss that your family has gone through and what your family will continue to go through. And I want to recognize that loss. The fact that there are the amount of people, the amount of letters, the amount of outreach on behalf of your son in his short life, the fact that so many people cared about him and loved him and are here to support him is something that everyone in this courtroom can say that we don't see it often. And his life was taken way too soon. And the court recognizes the profound impact that loss has had. And I want to make sure I emphasize that. The court also recognizes that Ms. Malik, you are young. You are a young woman.
Right away, the judge is drawing a critical legal distinction, acknowledging youth without allowing it to become an excuse. In sentencing, age can be a mitigating factor, but it doesn't erase responsibility. That balancing act between compassion and accountability is about to shape everything that follows. What do you think matters more in a case like this? The defendant's age or the outcome of their actions?
But youth does not excuse what occurred that day. The law takes it into account and recognizes that it is your youth that affects your decision making and it affected your judgment. But your youth does not excuse the foreseeable consequences of the choices that you made. And Mr. Hanfield, I want to thank the state, I want to thank you, Mr. Hanfield, your representations today. You have all been professional.
Now we're entering one of the most important legal phases of the hearing. The defense is asking for what's called a downward departure, essentially requesting a sentence below the standard guidelines. But notice the judge's focus. Remorse alone isn't enough. The court is looking at the totality of the evidence, not just the emotions expressed afterward.
You have represented your client, you have represented the state of Florida in the best way possible. And again, it's a difficult decision. And so I first have to rule, Mr. Hanfield, you made a motion for downward departure under 921.0026, both J and L, and I'll address those respectively so that the record is clear. The defense has moved for downward departure based on the offense was committed in an unsophisticated manner and it was an isolated incident for which the defendant has shown remorse. The court will find that the defense has failed to prove by competent substantial evidence and by preponderance of the evidence that has been met. Although I do believe that you are remorseful, I do not believe that this was an isolated incident of aggression towards the victim based on the evidence that was presented here in court. And I also do not believe that this was done in an unsophisticated manner. And the reasons why the court finds that is the most dispositive evidence of what occurred that day was the medical examiner's report. And reading that medical examiner's report and understanding that that was a 4-inch blade that was lunged into the chest near the heart, and it pierced a hoodie, it pierced a t-shirt, it pierced skin, it pierced tissue, it pierced muscle, it fractured a rib, and it ultimately pierced the heart. The amount of force that was required to inflict that wound was not accidental. There is uncontradicted evidence regarding that report, the testimony regarding that injury, and I understand that Ms. Malik, upon the incident occurring, indicated at one point that it was a result of horseplaying, at another point indicated that she had her phone out, and Mr. Lawler ran into the knife.
This may be the turning point of the entire sentencing decision. The judge is relying heavily on the medical examiner's findings, treating the physical evidence as the most objective account of what happened. In court, forensic evidence often carries enormous weight because it can either support or directly contradict competing versions of events. And here, that contradiction appears to be having a major impact.
Those explanations are contradicted by the medical examiner's report. And so for this court, the court needs to look into the intent behind that and the foreseeable consequence of pulling out a knife, aiming it at someone, and subsequently stabbing them in the area where you have multiple layers to protect you. You have your skin, you have your clothes, you have your ribs. And the force that was used penetrated all of those and resulted in the fatal injuries that the victim sustained. So under that ground, the court finds that the defense has not met its burden by competent substantial evidence. The other ground that the defense is relying upon regarding motion for downward departure is 921.0026. Under L, the defendant is to be sentenced as a youthful offender. The court has found that the defense has met their burden by competent substantial evidence that Ms. Malik does qualify for youthful offender.
This is a huge moment. The judge has just said the defendant technically qualifies for youthful offender treatment, but then declines to use it. That's an important distinction. Legally, can and should are two very different questions. The court determined it had the authority to impose a lighter framework, but concluded the seriousness of the offense outweighed that option.
But despite the court finding that she does qualify, there's a two-factor test, and that is whether or not the court can impose it, and the court finds that the court can impose it. The second factor is whether or not the court should impose it. And that's where this court has grappled, and this court has evaluated and analyzed, and I have gone over all the materials, not today, I've gone over it the weeks that it was presented to me, and the court has essentially come to the conclusion that because the sentence in this case must reflect the seriousness of what occurred, and because the sentence must reflect accountability, as well as the importance of protecting the public, the court cannot ignore the fact that a life was lost and the manner in which that life was taken. So at this time, though the court can impose youthful offender, the court will not exercise its discretion to impose youthful offender. So then what is the appropriate sentence? Ms. Malik, I have taken into account the documents that were presented on behalf of you, the evaluations that were conducted, the testimony that was presented here today, and the court does appreciate the comments that you made here today regarding how remorseful you are. And I think someone said it best, nobody wins here. And hearts are hardened, rightfully so, but one day, hopefully there can be forgiveness towards you. You are very young, and you will still have a life ahead of you.
Listen carefully to the language here. The judge isn't focusing solely on punishment. He's talking about rehabilitation, public safety, accountability, and the lasting impact on both families. This is often the hardest part of sentencing, trying to balance the future of the defendant with the irreversible loss suffered by the victim's loved ones.
You will still have an opportunity to become the nurse that you want to become, to have a family, to be with your family. But you have deprived Chemo's family of that. And for that, there needs to be a punishment. And the primary purpose of the Criminal Punishment Code is first and foremost to punish an individual for the crime that they're accused of, to punish the individual for the crime that they have been found guilty of, and to appreciate what has been lost and the gravity of what occurred. And so, because of that, I do believe that you're amenable to rehabilitation, and I do believe that you will get past this, but you have to be punished for it first. Because they have a life sentence of not having Mr. Lawler with them. And I can't overstate the profound impact that loss has been on their family, on their community.
And there it is, 17 years in state prison followed by 5 years of probation. After weighing youth, remorse, rehabilitation potential, forensic evidence, and the loss of life, the court arrives at a sentence it believes reflects both accountability and public protection. Cases like this often leave people divided. Do you believe the sentence was appropriate, too harsh, or not harsh enough? Let us know your thoughts below.
And the choices that you made affected the trajectory of all of their lives, and it affected the trajectory of yours as well as your families. You come from a very strong family that supports you, and they will support you throughout this. But the court needs to look at what is the appropriate sentence in this case. So at this time, I'm going to ask Ms. Malik to please rise. Ms. Malik, having heard from the state attorney's office, having heard from members of the public, having heard from the families, having heard from the doctors that testified, the court imposes the following sentence. At this time, the court will adjudicate you, Ms. Malik. The court will sentence you to 17 years in Florida State Prison, followed by 5 years of reporting probation. Special condition of that probation, you will have to go a mental health evaluation and abide by any treatment if necessary. You will have to write a letter December 20th of every year that you are on probation, acknowledging what had occurred and how it has affected your life. And I do not take this sentence lightly, Ms. Malik. This is not something that this court wanted to do, but I have to impose a sentence that I believe holds you accountable, recognizes the severity of the offense, and is something that's appropriate in light of everything that I've heard. So at this time, she will be remanded into the custody of the Department of Corrections to serve her sentence. Count 2 will be adjudication, 5 years. Please. 5 years. Then adjudication. 364. I'm going to appoint the office of the public defenders for purposes of appeal.
Judge, 364 for the visiting. Yes.